know how to protect yourselves when signing a business contract? In this video, I'll share the basics of Indian Contract Act 1872 and let's begin without wasting any more time.
Let's discuss the meaning and definition of contract. In simple terms, a contract is an agreement made between two or more parties. As per Section 2, subsection H of Indian Contract Act defines a contract as an agreement enforceable by law. Thus, any contract consists of two elements, that is, an agreement and the enforceability by law. In simple words, we can say an agreement, there should be an offer by one party and the acceptance by the other. That is, agreement is equal to an offer plus acceptance. As per Section 10 of Indian Contract Act 1872, all agreements or contracts, if they are made by the free consent of parties competent to contract for a lawful consideration and with a lawful object, and are not hereby expressly declared to be void. Based on the above definitions, Section 2H and Section 10, an agreement became a valid contract if it is made by the free consent of the parties and the parties must be competent to contract. There should be a lawful consideration and a lawful object, and it should not be expressly declared to be void by law. Now let us discuss the essentials of a valid contract. A valid contract requires an offer, acceptance, consideration, legal capacity, and the free consent. An offer is a proposal, acceptance is an agreement to its terms, consideration is the value exchange, the legal capacity means the being of the age and mentally sound, and mutual consent ensures the full understanding and agreement. Now let us see the essentials one by one in an elaborate manner. Offer and acceptance. Offer in a valid contract is a clear proposal and acceptance is when the party agrees, forming the contract. For example, when you buy a car, the price listed by the leadership is their offer to sell, and your decision to purchase the car at that price is your acceptance. Thus, a contract forms and you are obligated to pay and they are obligated to sell the car. This is a simple example for offer and acceptance. Consideration. Consideration in a valid contract involves exchanging something of value, that is, something in return for both the parties. The agreement is legally enforceable only when both the parties give something and get something in return. If you promise to pay your friend $100 to paint your living room, your promise to pay and your friend's promise to paint represent the consideration in the contract, showing that both the parties are giving something of value in exchange. Legal capacity. It means all parties entering into the contract must be legally eligible and mentally competent to contract. That is, the party should be of the age of majority, that is, he should attain the age at 18 years of age and be of sound mind and should not be disqualified from any law. An example of legal capacity is when someone who attained the age of majority and mentally capable signs a contract to buy a house, demonstrating their ability to make informed decisions and meet the legal requirements. Another requirement of a valid contract is free consent. A free consent in a valid contract means both the parties involved fully understand and willingly agree to the terms and conditions of the contract. That is, they should be of the same mind and on all material terms of the contract. It should not be arised due to coercion, fraud, or misrepresentation. Their consent should be free and genuine. For example, while purchasing a car, when the buyer and the seller agree to terms without any pressure, threats, or deception, it illustrates free consent in a contract. Both the parties willingly and clearly understand the deal, making it a valid agreement. Another features of a contract which makes it a valid one is intention to create a legal relationship. That is, the parties should agree with the understanding that their contract will be legally binding and enforceable by law. A social agreement will not form a legal relationship. We shall see this with an illustration, that is, An intention to create a legal relationship is when a person hires a contractor to renovate their home. Both the parties sign a contract detailing the scope of work, cost, and timeliness. This contract shows their intent to establish a legally binding relationship, as they understand that failure to fulfill their obligations could lead to legal consequences. On the other hand, a social relationship is just like the following. On the other hand, let's see this illustration. A friend inviting you to watch a movie together is a typical example of a social relationship. In this situation, the invitation is extended based on the mutual desire for enjoyable company and shared entertainment, and it doesn't involve formal legal agreements or obligations. Lawful object. A lawful object in a contract means that the contract's purpose or subject must be legal and not against public policy. It should not be illegal and immoral to the public policy. For instance, selling a car is a lawful object, while engaging in illegal activities is not. The contract's object must comply with a law to be valid. For instance, selling a car is a lawful object, while engaging in legal activities is not. The contract's object must comply with the law to be valid. Agreement not declared to be void. An agreement can be void if it violates the law or public policy, making it legally unenforceable. For example, an agreement can be declared void in cases like a contract for selling stolen goods. If two parties have a written contract for such a transaction, it is considered void because it involves illegal activities, making it unenforceable in a court of law. Certainty and possibility of performance. In a contract law, certainty means clear and definite terms, while possibility of performance indicates that the obligations in the contract must be realistically achievable, not relying on the impossible or uncertain. For example, in a construction contract, the builder agrees to construct a house for a client, which is an example of the possibility of performance. As long as the contract is feasible and within the builder's capabilities, it's legally valid and both parties can enforce its terms. Legal formalities. Legal formalities in a contract law are the specific requirements like written agreements, signatures that must be met for a contract to be legally binding. These formalities ensure a contract's validity and enforceability, and not following them can make a contract void or unenforceable. For example, buying a house involves legal formalities such as signing a written contract along with other customary steps like inspections and disclosures. These formalities ensure the validity and enforceability of the property purchase contract. In conclusion, the Business Law or the Indian Contract Act 1872 provides a robust legal framework for businesses. Understanding its provisions and implications is essential for successful operations. By adhering to the Act's requirements, businesses can ensure legal compliance and protect their interest. Hope you understood the basic requirements of contract and its essentials. Thank you.